Okay.
Your time's expired. Thanks,
Yes, sir.
John.
Thank you.
Yeah, thank you.
Next case on the docket is HANSEN and BERGERON versus City of DELAND.
Good morning. May it please the court, my name is Bob Dilge. I am here with Thomas P. Callan of Thomas P. Callan, PA. We represent the appellants in this matter, Roy and Jane HANSEN and Clifford Bergeron. Your Honor, this is an appeal from a hearing to determine liability in an inverse condemnation case.
Do you agree that the trees were part of the real property and not personal property?
Yes.
Okay. So the question is whether there was a taking of the real property as a whole, correct?
That is correct. And then the trees would be a damage sustained by the use of that property by the city.
Do you have any case in which any governmental entity has been held liable in inverse condemnation for a single unintended act of flooding without the element of expectation that that would recur in the future? I mean, I've seen cases where, you know, there's a continuous flooding.
Yes.
Where they dam up property and flood for all time of the property. And I've seen cases where the county did something or some governmental agency did something to create a recurring flooding that's expected to recur into the future, where it's been found to be compensable in inverse condemnation. But I haven't found any case like this where it was a one-time event. It's not expected to recur, and where the government's been found liable in inverse condemnation.
Yeah. Your Honor, as you know, Florida law now recognizes a temporary taking. The first English case, the United States Supreme Court recognized a temporary taking. In Kenworth Tractor Trailer, the Florida Supreme Court recognized a temporary taking, and then this court in Meadow Lake recognized a temporary taking.
But even in Meadow Lake, the language used talks about a taking that's temporary with recurrence into the future expected.
But the problem had been rectified in Meadow Lake so that it was, in fact, a temporary taking. In fact, Your Honor, the idea of a temporary taking actually goes all the way back to the Dickinson case, where you had a dam placed in that flooded the plaintiff's property. He then came in and remediated the problem, and the court still said, even way back then, way before the first English case, that the property was taken when it was taken, and the government was required to compensate for that.
Mr. Dills, why isn't it a trespass? Why isn't it a tort?
Because it is for such a duration. If you have a momentary event, then that may be a trespass. But in this case, what you have is a case of physical invasion and appropriation, use of the property by the city for a stormwater retention pond for 15 months. 15 months, Your Honor. Now, bear in mind that this was a purposeful act by the city. When the Cross Creek subdivision flooded, the city, as the court said, came to the rescue. It needed to do something to protect those properties that were being flooded, and the only thing it could do, the only place where it could put that water, was in the dry pond that was adjacent to our plaintiff's property. Now, the city came in and it pumped water for 78 days. As the court recognized, the water very quickly began to rise, and the city did nothing because it couldn't do anything else. It had to have that property. It needed it for the public purpose of a retention pond. And so it pumped, and it pumped for those 78 days. The water eventually reached a depth of 14 feet. If you look at what the city did, it pumped 6 million cubic feet of water. That's a football field 138 feet high. And the water...
I think we're all familiar with the facts. I think what we're interested in is probably the law. And I still haven't and I looked a lot too. I mean, I read the briefs, but I did my own research and looked at a lot of other states and federal law, and I couldn't find any case where it was a single event, like this where it was found to be a taking. I found plenty of cases where it was found to be a tort claim, a negligence action basically, but none where it was found to be a taking. Can you?
Your Honor, if you look at the Drake case,
I read the Drake case.
The second opinion recognized there were two takings. The first one was ended in 2005, so that became a temporary taking. And then after 2000,
but in all those cases, it was they redirected the water or did something so that sort of a permanent event. I mean, unless you did something else, there was going to be a permanent flow of water or a recurring every time there was a rain flooding. And they use that language. They talk about a temporary deprivation, and I could read the standard, but they talk about recurrence into the future as part of the test as to whether there's going to be a temporary taking or whether the flooding is going to be treated as a tort matter.
That's true in the rain cases, but if you look at the Drake, I mean, there they put in a drainage system that was defective. It flooded the property for a period of time. That was then...
You're talking about the 2009 Drake case?
Yes, the latest
right.
one.
Okay, I have it right here.
But the first case, the first taking that they find was temporary because it was rectified, and then the problem...
We have previously held that a county takes private property when it directs a concentrated flow of water from one property onto another, permanently depriving the owner of all beneficial enjoyment.
Your Honor, that's
not what we have here,
the
right?
first DCA,
right.
And it's not this court in Meadow Lake, and that cannot be a correct interpretation of the law if you recognize...
Now, I'm confused.
Then it goes on to say that a substantial interference for more than a momentary period, which either will be continuous or reasonably expected to continuously recur, thereby resulting in a substantial deprivation of the beneficial use of the property, is also compensable. So no, it doesn't have to be permanent as long as it's continually recurring or expected to recur and results in a substantial deprivation of the beneficial use. And I mean, that seems to be the standard. Doesn't look like that's what we have here.
Well, what you have, though, is what would be a permanent taking, but then the city stops pumping the water, and in 15 months the flooding goes down. If Your Honor follows the reasoning you're espousing now, then you wouldn't have such a thing as a temporary construction easement. Anytime that a governmental entity wanted to use your property for a retention pond or to put tractor trailers on it when they were building a road, then they could come in and they could put them there. They didn't mean to have it there for a long period of time. At the end of 10 months, 2 years, 10 years, they remove the tractor trailers, they cease using the ditch, but during that time you were required to allow them to occupy that property. You gave up your fundamental right to say, no, you cannot.
Would it perhaps be a different case if they pumped onto your client's property? I mean...
I'm sorry?
I mean, if they... You said that this is an intentional act, and it is sort of an intentional act because they intended to pump the water, but they didn't intend to pump it on your client's property. They intended to pump it into a drainage pond somewhere else. And it was proved, although disputed, it was established, the trial judge believed you're expert, not the others, that water seeped through the ground. The groundwater flowed onto your client's property and filled up the sinkhole, or what used to be a sinkhole.
Yes. But once they see what's happening, and the trial court indicated that this happened very quickly in his findings, then the city needs to do something to prevent it, at least before the 30 days when the trees are all going to die. But the city couldn't do anything else, and so it used that. It took it for its own purpose. One of the fundamental rights of a property owner is to possess property, to be able to dispossess it, and to tell the government that it cannot use the property. In this case, for 15 months, our clients were denied their fundamental right to tell the court, to tell the government that they could not.
I don't know that this even makes any difference, but I don't recall. Did your clients ask them to stop pumping, or tell them that?
Yes, they were out there. In fact, we filed a lawsuit while the property was still flooded, but the city couldn't do anything about it. That was the problem. They had no other place to put the water, so they needed a retention pond. In a regulatory taking, a government may be able to limit your use of a property, but it cannot come in and take property and use it for its own purposes without providing compensation for that. In terms of fundamental fairness, the whole principle of condemnation and inverse condemnation is that an individual property owner cannot be asked to bear more than the fair share of the burden.
Let me ask you this. I'm confused about your position about the applicability of the Meadow Lake case. And the reason I'm confused is you cite it throughout your initial brief. You argue it today for authority. When the city talks about it in its answer brief, in your reply brief, in a footnote, you say because Meadow Lake involved inadvertent periodic flooding, not a purposeful continuous flooding to preserve other property, its application is inappropriate in the instant case. So can you tell me whether you think Meadow Lake is analogous to this case, is not analogous, is it appropriate to consider it, or isn't it?
Meadow Lake, I don't know what this court meant by Meadow Lake, to be candid with you, Your Honor. Meadow Lake deals with flooding that recurs. And you have this long evolution of cases. They start off in Dudley case and Poe, and they're very skeptical of this because it's not permanent. And then you get to the Kendall and the Gutierrez case, and they say, well, flooding is, rain comes periodically, and every time it rains, it floods, and therefore you have the permanency that you need. Now, Meadow Lake comes in and does away with that in the case of where you have rain that comes periodically and floods the property. But this is not that kind of a case. If Meadow Lake is trying to set up a special standard, that denial of any reasonable use that applies to a flooding case where the government may inadvertently hamper the drainage of a park or whatever it is, or where the government may build a highway that inadvertently dams up property, if it means to establish in any reasonable use special standard for periodic flooding by rainfall, then it doesn't apply here, because this is a purposeful act. It is the taking of an easement for the government's use. It's like the Dickinson case. I think the Dickinson case is very helpful in this instance, because what Dickinson says, and that's the United States Supreme Court decision, is that if you have in effect taken the property in such a way that would have established a servitude as between private parties, either by agreement or by time, then you have a taking. Now think about that, Your Honors. If somebody wants to use your backyard, and we're talking about 3/4 of an acre or 1/4 of an acre, if they want to use that for a retention pond, are you not going to demand that they pay you for that use? I mean, that's what Dickinson's all about. We have what is in effect a servitude. Your Honor, I would reserve the remainder of my time.
Let me ask you one more
Yes.
question before you sit down. You quote extensively in your brief from a VLX opinion from this court that was withdrawn and replaced by another opinion.
That's correct.
It has no authority at all, to my understanding, and I'm just curious why you would cite from an opinion that was withdrawn and replaced by an in-bank opinion.
Because the VLX opinion that substituted for the first one, the one I have cited from, was based on the fact that when the court went back and looked at this situation, it found that Southern States Utility had in fact acquired a right to use the lake, the golf course, for reclaimed water, and therefore it could not have been a taking. But in the original opinion...
But it totally takes the place of the first opinion.
It does, Your Honor.
It has no authority whatsoever. It has no precedential value. You don't know why a particular language that was in the first opinion doesn't show up in the other opinion. But it's my understanding that it's withdrawn. It's as if it was never there. And I've just never seen anybody try to cite to us an opinion that was withdrawn and has no precedential value.
To be candid with you, Your Honor, it is an opinion that needs to be before the state of Florida, because you analyzed takings in a very effective fashion, and you showed the very problem that has arisen in this case, where a court applies the rule for a regulatory taking to a physical invasion taking. That decision reflects the thinking of this court. The trial court relied on decisions from the first DCA, which are not accurate because they impose a substantial or a beneficial, all beneficial use standard. That's not the law for a physical taking. And I would point out that in those first DCA cases, every one of them, the Smith and the Schick case and the Drake case, all of those dealt with a portion of the property. What the trial court did in this case was to ignore the fact that when you take a portion of a property in a physical invasion case, you apply the per se taking to that portion of the property that's affected by the taking. Now, all use of that property of the property actually taken was denied in this case. But, Your Honor, when this court looked at VLX, it pointed out, for example, that in the Sarasota welfare case, this was just a pipe put underground on a portion of the property. That was found to be a taking, even though that court misapplied or applied the regulatory language about denial of substantial beneficial use. And this court said, no, that was the wrong standard, and pointed out that the court in Kiesel came back and corrected that, and Kiesel was a situation in which you built a bridge which interfered with an impertinent right of the property owner, the right to see the water. And so even an interference with an impertinent right is considered to be a taking. I would reserve the rest of my time here.
About 4.5 minutes.
Good morning. May it please the Court. My name is Ernest Kohlmeyer, and I have the privilege of representing the city of DeLand in this case. And I wanted to merely address some of the issues that were pointed out by the panel and to present our argument as we have presented it in our brief as some certain points. First of all, I think Judge Lawson hit the first point in my argument is the fact is the standard is well defined. The appeal in this matter, in our view, and what I've argued in the appellate brief, goes into twofold. Number one is whether or not Judge Rowe used the proper legal standard. It's the city's contention that he did. He used it, cited case law in the Walton County case and as well. And the essence of those opinions are through the test of continuous, permanent deprivation. And if there's any theme in this appeal is the law as it's established attempts to separate out on a case-by-case basis acts which may constitute a trespass or a tort versus acts that reach a much higher standard, which is a taking. And those elements are ingrained in our law and what the standards are to support an inverse condemnation case, which would require a governmental entity to pay damages, in essence, buy a property for the loss of the deprivation of the use of that land. In this instance, as Judge Lawson recognized, this is a one-time event. And although that candidly, the duration was disputed, given the fact that in our trial, and I don't want to get too much into the facts, but the fact is our expert opined, and just for clarification, opined that some of the water may have contributed from this dry retention pond. It seeped into the ground and may have contributed to that area. However, our expert opined that what happened... I mean,
the trial judge rejected that testimony.
That's true,
found
Your Honor.
that, so
that's true, Your Honor.
That's what we have here, a finding of fact that is supported by competent substantial evidence that it was your client's pumping that caused the flooding. So
yes,
that's
and that's not disputed that there may have been some, but it goes towards the duration. But what is in essence in this case was that the trial court found, as a matter of law after a 3-day trial, that there wasn't a deprivation of the use of the property. The property was habitable. The people both lived in the house. Their backyards was flooded. In fact, he recognized that Mr. Bergeron was on vacation, or he maintains a separate home outside the state, and he had no knowledge. His daughter came by and saw that the property had some water on it as well, but the property never entered into the structures, or people never lost the actual use of the property. But the real reason, the real crux of this case...
Do you agree that there could be a temporary taking?
I believe that there can be, but you still have to establish a taking. And I think the temporariness that comes into play, and the distinguishment is when...
well, let me ask you that. If there is a temporary taking, the person's entitled, or the people are entitled to compensation?
That's correct. If a taking has been done, but you have to show the elements of that. And I believe in this case is more akin to a trespass. Opposing counsel got up and argued the fact is that...
Mr. Bill says that at some point it becomes a taking. You know, I don't know where you draw that line, but if this was 15 months, maybe that's a taking, and if it's 2 weeks, maybe it's trespass.
Well, I think that's why the case law looks at this on a case-by-case basis, and it measures certain things as the continuousness or the intermittent or the frequency of that. A lot of the cases, and we've done some serious research as well to try to find out if there is a case similar to this, and there isn't one. A lot of the cases go on the fact where a governmental entity or a water management district alters the direction of flow of water in which, caused by rain, that may not flood for a particular period of time, but the likelihood that it will reoccur in the future allows the property owner to have dry spells and spikes up and down, that would cause, in essence, over a duration of period of time, a loss of economic use of the property or beneficial use of property.
And courts have treated that as a temporary taking, correct?
I believe that it recognizes that could occur, that those situations could occur and those compensations could be done, but as the cases have pointed out, there has to be a permanency of that condition. In this case, there is no permanency. This was a...
Let me ask you, the Florida case, I think, I don't remember the name, that recognizes temporary takings was a truck case. It was a personal property case. And the government seized a truck for...
FHP. I think it was Florida,
yeah.
FHP.
For a couple of years and then gave it back. So,
Right.
So that was a one-time event. They're not expected to take the truck again. Why wouldn't that same reasoning apply here? I mean, you took, arguably, their property for the same amount of time, roughly, that the government took the truck in that case. Why isn't that case applicable, and why isn't it a temporary taking?
Well, I think that the essence is that and I think what Judge Rowe recognized is that you have to look at what the deprivation was. If, in fact, in those cases where you seized the truck and you absolutely have no use of the property anymore, you can't use the truck because it's been taken from you for a period of time, that's been a deprivation of all economic beneficial use from that truck.
So because there's that second prong of the test, which is denial of any reasonable use, and of course there's questions as to whether that's correct, but that's the way Associates of Meadow Lake versus Edgewater says it. A denial of any reasonable use of the property. Are you relying solely on that? You're saying if it had flooded the driveway so that they couldn't have gotten in, even though it would be a one-time event, everything else is the same, one-time event, water pumped onto somebody else's property, seeps over, but now they can't get to their property. Would you say that would be compensable?
If they couldn't get to their property and they could not use it as a residence for a period of 15 months consecutively, then I think that would amount to a taking. But in this case, as Judge Rowe showed in his opinion and through the trial, the plaintiff...
So you agree then that the flooding was enough to constitute a taking, given, just depending on how much it deprived the plaintiffs of their use of the property?
Yes, and I think that the trial court recognized, and when we were looking at it, I think that was the cruxes of opinion when he talks about...
So a one-time flooding event is enough. A one-time flooding event is enough, even if it's not expected to recur, depending on how it affects the property owner.
If the duration and the occupation of the physical invasion deprives them of the economic and beneficial use of the property, then I think you can get into the realm where you've crossed that threshold. But in this case, as Judge...
How do you square that with, say, construction easements? In other words, if they use this 3/4 of an acre to pile some sand on or put a construction equipment on for a period of 15 months, certainly it wouldn't deprive them total use of their property.
Sure.
But still, you would agree the government would owe them some money for that temporary use, correct?
Well, Your Honor, I think...
What's the difference?
Well, I think the difference is when you look at it on a case-by-case basis, and we're talking about...
In other words...
we're talking about where does the line in the sand draw, and I think that's why the trial court...
It's water as opposed to, a backhoe. I mean, what's the difference?
Well, I think the difference is the fact is when you get down to looking at it, when you're talking about a physical invasion that you're having the trial court on a case-by-case basis make a distinguishment between a trespass or a continuing trespass and whether or not they've reached the level of a taking. I think the construction cases where there may be other methods that go on. If you park construction equipment on the property and it sits there, you can certainly have remedies to go out and have them dispossessed with it.
That's a temporary
and I look at that,
taking, they get an easement.
and I think, well, I look at that more as a trespass. You're parking equipment,
Well, but I mean,
and you're entitled to compensation
Oh,
for an unoccupiable,
they look at
basic.
it as a kind of a temporary taking for purposes of something. I mean, they compensate an owner for it. The law provides for that. And it's not a taking of their whole property. In other words, they're not deprived from the whole beneficial use, but it's a use the government takes for a period of time to do some other act. I mean, I don't see the difference, to tell you the truth.
Well, Your Honor, I think that the case law, the reason why it is set up this way, and I think if you look at, and since this was really argued, when you're talking about what is the standard of what has gone on in regulatory takings, I think the first DCA has also retreated, and I think the Supreme Court has retreated in some of the Lucas opinion. Lucas versus South Carolina has retreated from this all-encompassing temporary takings when you're talking about regulatory takings. When you deprive someone of, because of a permit, that they can't build for a period of time, and then you pull it back and say, well, I get rent because you deprived me of going forward. The courts in Florida has said, that's just incident of what's going on here. We don't automatically pay rent because you're held up a little bit. That same concept falls in the same thing of physical occupation, and particularly I think what a concern, especially when we're here in Florida, when you're talking about flooding and the period of time that we're talking about, which we had as factual evidence in the case, from June of 2005 until October of 2005, following the hurricanes of 2004, was historic water accumulation in the state of Florida, particularly the DELAND area. So, and I don't want to get into the facts, but we're talking about a one-time event based on historic rainfall events as well, far different, where the government intentionally, and I think it goes back to Judge Lawson's point, is what was going on in this matter is the fact that they were not pumping continuous water on there. They were trying to alleviate the flooding of the front of the subdivision so people could have, which was the only way in and out of the subdivision, was to be able to egress and ingress into the subdivision. They were pumping water and regulating it into a retention pond physically on the subdivision's property, and regulating the flow to make sure that the people and the occupants could, and flooding of the houses were not done in the front of the subdivision, but also regulating to make sure that it didn't overflow the banks of the retention pond in the back. And I think the judge realized, no good deed goes unpunished. They get sued for the water seeping into the ground, and it, at least in our part, contributed some to the flooding. We believe that most of the water in the back was caused by natural occurrences. The main question in this case is the trial court has the discretion to weigh all the evidence in this case and draw the line of the facts, of the circumstances that you presented to me. Where does this case fall on in depending on the line? Is it a trespass? Is it an inverse condemnation that requires just compensation as a physical taking, a temporary taking? This court found that there was a deficient in evidentiary evidence put by, that there was a complete lack of evidence that both Mr. Bergeron and Ms. HANSEN, their properties did not suffer the threshold requirement of whether or not they were deprived of all beneficial and economic use of the property. And he stated specific reasons for that. They were allowed to enter the property. And I asked them in the trial court, in this part of the record, do you consider the aspects of this case to be, the backyards of being aesthetic? Yes. It wasn't for commercial use. It was their backyards, and I understand that. But where the area was flooded, and this whole area was flooded, that it was merely for aesthetic value anyway. It served no beneficial or economic use during the period of flooding, and therefore the court found that they did not put in enough evidence to show a complete evidentiary.
Let me get back to the one I gave you before as an example. Suppose they parked a backhoe back there.
Okay.
And they were using it on a different project, but they certainly would be deprived of all beneficial use of their property. If they kept the backhoe there for 15 months, they'd be entitled to compensation for a temporary taking of a construction easement.
Your Honor, I don't believe.
Instead of a backhoe, it was water. So,
Your Honor, I don't agree that parking physical equipment on a piece of property automatically amounts to a taking where you have to pay rent. I agree that there were
Did
circumstances.
they put an antenna up there for something?
Well, that would be more permanent.
Huh?
I think that would be.
They only need it for 15 months.
Well,
I mean, could government go in and do that without paying for it?
no, because the law allows other torts to compensate people for that there is a trespass element. And I think the reason why this isn't a trespass, to be honest, is there's a sovereign immunity cap and there's no attorney's fees provided for torts in that case. This is why this is an inverse condemnation. This is more appropriate, if anything, as a tort. But the law is, and I think as opposing counsel argued, is, and what Judge Lawson has recognized is that in order to meet a taking claim, the law has been specifically and purposely held to a much higher standard where the effects of a taking as far as paying just compensation and paying attorney's fees for proving that amounting to an eminent domain proceeding. And that is in essence what this is. That's the equivalent where there is no eminent domain. What?
That is exactly what
It is. But you have to, under the same realm, you have to still follow that where the reason why you're being compensated is because the government has acted in a way that would continuous
Do the cases
deprivation.
have different or special standards for flooding cases?
Well, I think that is in differentiating to regulatory takings.
No, I mean, if you park a truck on somebody's property temporarily, or if you take their truck temporarily, or you do something, a physical kind of invasion, it seems like the courts have grappled with flooding cases and have laid out some standards that don't seem to work anywhere else.
Well, I think the language that Judge Rowe used as far as the substantial ouster language, and as well as the language where you're talking about continuous occupation, that takes into account where there may be peaks and valleys of this intermittent flooding in that. But I think one of the important language when you're talking about flooding, the differential in some of the language that it was in the Meadow Lakes case, and also in the Drake case, is that they have set up a standard to make sure that this is an ongoing issue of some permanence or some repetition to account for.
I guess what I'm saying is, if you read flooding cases,
Yes.
you seem to win based on the standards that are set forth in those. If you look at broader concepts and look at cases in other instances, it doesn't seem that you should win applying those broader concepts, because it seems like you invaded their property for 18 months and they couldn't use their backyard like anybody would use their backyard. And you can make a good argument that that's really no different from putting construction debris on someone's property for 18 months, which I think if you looked at the law, you would find that clearly would constitute a taking. So I'm sort of grappling with this language which puts out a standard for temporary taking, which suggests that there has to be something more than temporary invasion. It has to recur or be expected to recur, and cases from other areas which of course don't have that kind of requirement in the temporary taking context.
Well, I think that's a unique and a very interesting issue, and I think and I don't know if that's purposeful or not, but I think flooding or when you're talking about drainage districts, and I think a lot of cases fall into that line, when you're talking about municipalities and they seem to come up where there's an alteration in a flood pattern or a design in some way where there's maybe some alteration in the flooding level of some property, or there's an alteration in a draining pattern or something like that where it may be not so much intentional. I think the law, as it has been established in the first DCA and some of the cases that we cited, and also a little bit in the fifth DCA opinions, are purposeful, because it is a unique animal. We're talking about flooding that may be controllable, it may not, it's kind of questionable. Other than parking a truck on a piece of property that may be deliberate in a way, flooding is a little bit more difficult to lock down. What is the cause of the flooding? And particularly in this case, a lot of the evidence in the trial court was what was the cause and what proportion of contribution of the water was contributed to natural causes or for the involvement of what the city was pumping into the dry retention pond that was off-site. I think that the language is purposeful specifically to what these flooding cases are for, and I would urge the court to stay within that realm because I believe that the language that are used in this case as it is treating to flooding cases is purposeful for the aspect of flooding. And therefore, rather than broadening it out to encompass it all, that these cases have narrowed this down to account for this unique event. And I would agree with Judge Lawson that if this is a flooding case and we apply this to flooding as it incurs this case, we believe that the city is entitled to an affirmance of the opinion. The other part in my brief, and I know I have about a minute and a half left, but I want to point out in this case, Judge Rowe applied the right standards. When you look at his opinion, he cited the Walton case. It was subsequently amended later on, but the standard of law
He relied
did not
heavily
change.
on the Bassor case, didn't he?
He also relied on the Bassor case, yes, Your Honor. He cited the Meadowbrooks case. He cited First English. He took all this into account. And part of my brief and what I went into, and it's no stranger to the appellate court, the appellate's role in this case is to review Judge Rowe's opinion and not retry the case and look at the facts to see if Judge Rowe may have come out with a different opinion based on your review. Whether or not there was substantial competent evidence for Judge Rowe to make the determination, and we're talking about line drawing, and that's what we've talked about through my presentation here today. Judge Rowe, after a 3-day trial, is the appropriate person to draw the line. He found that there was no temporary taking, that there was no taking in this case, and even cited at the very end to go to the panel's question on this, it may have been a tort, it may have been negligence. That was not brought in this case. That was an option that they caught that they chose not to bring. You have to make all the elements of the case by proving a substantial ouster of the property. They did not provide that through evidentiary testimony, and therefore Judge Rowe's ruling was right on the law, and as a trier of fact in this case should not be disturbed by this court. I'll end my time if there's no further questions.
Thank you, Counsel.
Your Honors, I would just point out that in the Meadow Lake case, the court concludes because the trial court's order presumed that no taking claim could be brought by associates because the condition allegedly caused by Edgewater had been remedied, the order dismissing associates' complaint with prejudice is vacated. I mean, that was a temporary taking. I would go back here on...
I ask you to address the Bassor case because you don't at all in your brief, and that seems to suggest that you wouldn't win. In that case, there was flooding of the property which damaged a lettuce crop, and compensation was, I think, given below, and there was a reversal saying that because it was not intentional, it was more of a negligence thing. It wasn't. It was treated as a tort claim and not as a taking. And the trial court relied on it. They briefed it. You don't even mention it. You want to address that case?
Yes, because that dealt with the flooding of a crop, and it appeared to have been a one-time event. There was somebody failed to shut a valve on a dike, and as a result, water overflowed, destroyed the lettuce crop. Now, that's a trespass kind of a case. It was just for a short period of time. It was remedied immediately. There was nothing like the 15 months. It wasn't for a public purpose. So I think that gives you the one in.
So the duration is the difference.
Excuse me?
The duration of the flood event?
It's the duration and not taking it for a public purpose. I mean, if you go back to what the fundamental...
Let me ask as a follow-up. I took some notes from cases from the computer screen, and I don't know which one this is, but whether a taking has occurred depends on the facts of each case. It was a flooding case. Specifically, the nature, extent, and duration of the intrusion. And I guess, there's so many factors here at play. Do we treat this, as counsel for the city suggests, as really a factual call, having heard all the evidence? I mean, this is a close call. The trial judge made the call, and we should defer, or is this really a question of law?
It's a question of law, Your Honor. The judge in this kind of a proceeding determines the facts, and then he applies the correct standard to that and determines as a matter of law whether a taking has occurred. In VLX, this court recognized that where the judge applies the wrong standard, then he has to be reversed.
Just the published VLX opinion?
No, that's in the unpublished one, Your Honor.
You should stop citing that.
I understand. Well, let me go back to a decision cited in there, which is Schick, and this lays out the basic law. It's an inverse condemnation case. for a physical invasion is entering upon private property for more than a momentary period and under the warrant or color of legal authority, devoting it to a public use. That's the Schick case that was cited by
But I mean, isn't that one of the I mean, I think that if they had said, oh, here's some sinkholes, let's pump into there, and had moved the pumps over and pumped into the sinkholes, and had done that for more than a moment, I mean, probably at all, that would be clearly a taking. I mean, it seems like a different case if they're pumping onto someone else's property into a retention pond, and the water makes its way to your client's property.
But when they know it has come and they do nothing about it...
And it's no longer negligence, you say?
It's no longer negligence. It's a purposeful taking, Your Honor. The fundamental premise of eminent domain and inverse condemnation is that nobody should have to bear a greater burden than anybody else for public works. In this case, our clients have, as taxpayers, they have to pay for the pumping. They have to pay for anything that the city does over there in Cross Creek. That's what the burden they bear as citizens. But they do not have to give up a quarter of an acre or a third of an acre of their backyard for that purpose. That's an extra burden that's imposed upon them. Judge Jacobus is absolutely correct in looking at this in terms of a temporary construction easement. Nobody quibbles about that. Every time the DOT engages in road work and takes property, it in the routine takes temporary construction easement and it pays a certain amount for those. Your Honor, we would ask that this court reverse, that it remand to the trial court with instructions to enter a judgment of liability for a taking, and that it remand or turn the matter over to a jury for determination of full compensation. Thank you, Your Honors.
Thank you, counsel. The court will take its morning